Okay, so this is Chapter 7, Part B, the remaining slides from this chapter. And we just finished with the state courts, and now ready to talk about U.S. district courts. The U.S. district courts are the trial courts at the federal level. And again, they also have both federal or civil and criminal. There's at least one district court in every state. There are 92 all over. And these are the courts of original jurisdiction. In Missouri, we have two districts, the eastern, or maybe it's three. We are in the Eastern District, and if you go down on Independence Street, Federal District Court is there, as well as in St. Louis. And so there can be more than one courthouse. And then, of course, the Western is in Kansas City, and I believe Springfield. And I don't know whether there's a central or not. Illinois has three, and theirs go north-south and central. So, but much bigger state as well, too. You'll see a lot of federal drug prosecutions there. Those bank robberies, if it's a federally insured bank. The cases have certainly grown. Here you'll see a little bit of everything. Probably drug as much as anything. Cases involving crossing state lines because of the proximity with Illinois and Kentucky and Arkansas. Those take on federal jurisdiction as well too. The other thing we're going to add here is that in district courts, they will have a U.S. magistrate, and the magistrate handles the minor cases, just like in state court, and he or she oftentimes will be the person that the FBI or DA or federal law enforcement will go to when they're wanting to get a warrant. So it's an important job. Probably doesn't have the prestigious trials of a federal district court judge, but sometimes it's a stepping stone to get there. The U.S. Courts of Appeals, there are 12 regional circuits. We're going to see a map here in a second. Oftentimes these are called circuit courts or the Circuit Court of Appeals. And these courts only have appellate jurisdiction from the district courts that make up each circuit. The appeals usually fall into one of those three categories. And the non-consensual are the ones which probably bring about the most change. Frivolous means there isn't much change. Ritualistic, automatic appeals, and like death penalties and things like that. There's your map of the circuits. You can see we are in the 8th Circuit, which is a number of states. Illinois is in the 7th, with just Wisconsin and Indiana. So they really vary. Now, if you go out in the 9th Circuit, look at all the states: California, Nevada, Alaska, Hawaii, Montana, Idaho. That's a huge circuit, as opposed to the 2nd Circuit, and some others. So they just vary. All right, so the power of judicial review, U.S. Supreme Court. And we get back to our old term here, the writ of certiorari, which you've already talked about. And they issue that to the original court to send up the case for review. Remember, it has to involve a constitutional question, if it's from the state courts, and a lot of the others, but they hear civil cases as well too. So roughly about 5,000 cases per year, and 200 or less are actually going to be heard. In order to grant certiorari, as you see, 4 justices have to agree to hear it. All right, these are kind of the steps in the court process. Notice initial appearance or first appearance within 24 hours, or excuse me, 48 hours. And it's basically to make sure there was probable cause, the defendant knows his or her rights, they've gotten an attorney, and possibly the chance to make bail. And we'll talk about bail here in a second. The next stage is accusation. You have to be formally accused. Traditionally, that has been handled by the grand jury, and we'll talk about that. If the grand jury does reach a formal accusation, then there'll be arraignment, where you're read the charges and you're asked to plea. Okay? And then, of course, it will go on to trial. All right, bail is pretrial release. The whole idea of bail started in England way back when judges rode circuits, and they may not be back for months at a time. So if somebody got arrested and someone could agree to be what we call their surety, S-U-R-E-T-Y, and that means they would vouch that the accused would be present for trial when the judge returned, and if that person wasn't, then the surety would have to stand trial in their place. The idea of money bail is an American development, and of course, geographically we're so much bigger, and particularly during the particularly early 18 to mid 1800s, when people started going west, it was very easy to skip bail. So, and you would leave the surety hanging. So now they introduce the idea of money bail, or a security where you put down a financial pledge and you get it back if you appear, and if not, you forfeit it. So I want you to put a double star by those two purposes. The main appearance, we call it the manifest function of bail, is to ensure appearance for trial. And the second is that they should not be punished until they're convicted. So if you hold people in jail, and some people are a threat, so you have to do some, but particularly for a lot of minor offenses, they have to go on, or the family has to go on some type of legal aid or assistance, because they can't afford food and shelter, and of course the person's probably going to lose a job and everything else. So today we talk about the bail bond. And the bond is a document that simply guarantees appearance for trial. All right, bail is governed by the 8th Amendment, very loosely we might add. All it says is bail shall not be excessive. I don't know what that is, and that's a relative term as well too. The most common things, and you can read all these in your book, are deposit bail, and most states run on a 10% system, where if bail is set at $50,000, you deposit $5,000, 10%, and pledge on the document to pay the rest. If you appear for trial, you get usually 90 to 95% of your $5,000 back. They keep a little for administrative cost, because there's always paperwork, but that has worked fairly well. The other one is ROR, release on recognizance, where you are released without posting any money or property, but most of the time you have to have lived in the community for a certain time period, have employment there, have family. They want to see ties to the community. And ROR has been really good about taking the expenses of bail away from people that are likely to show. The other one is third-party custody, which is the professional bail bondsman. Somebody puts up the money for you, and then pledges. The professional bail bondsman has got a really bad reputation, particularly because of their retrieval practices and a lot of corruption. So they get 10%, and that's where we got the idea of deposit bail. So generally, if I put up money for one of you, and your bail is $50,000, and I pledge $50,000 if you don't show up, you owe me $5,000, no matter what. Okay, but that's to secure your release. So, and like I said, you can read those others, but those are the three most common. Danger laws, some states, protection laws. There are obviously some very dangerous felons out there, criminals, and you can, in fact, deny bail or set bail real high in order to protect the community. So that's not probably going to happen with a burglary, but certainly a violent offender, and particularly a repeat violent offender, we can deny. Murder is usually the one crime that is non-bailable. They can set it, but they don't have to. The others they do, but they set it high. So a drug dealer who'd use violence probably is a danger, and he or she won't receive bail in order to protect the community. All of a sudden witnesses turn up missing or dead, or so. And here, this shows you the people released. So, as you might say, might have guessed, for murder and rape, murder has the least. Although assault, most of those people get released. Burglary, they get released. But burglary is less than assault. Theft, drug trafficking. All right, we said a few minutes ago that one of the steps after the initial appearance was, and after bail, is accusation. The Fifth Amendment guarantees that you have the right to a grand jury proceeding. Grand juries are only accusatory juries. They do not hear evidence. They do not determine guilt or innocence. They simply decide who's going to trial. So it starts out like this. The prosecutor, after an investigation, will summon the grand jury, and it can be from 12 to 23 members, depending what state you're in. In Missouri, it's 12. And the prosecutor will present the state's case. There's no defense. There's even no defendant because no one's charged yet. The idea is to determine, was there enough evidence? There is no judge. As you see, the hearings are held in secret because there's a big stigma for this. The defendant doesn't appear, may not even know he or she's being investigated. Like we said, there's no right to an attorney. There's no cross-examination. And then at the end, the grand jury issues a true bill from that bill of indictment, which means we're going to charge that person with murder or with the crime, or no bill, which means there was not ample evidence to charge. Now, that is your constitutional right to have a grand jury. But the other way is to proceed on the basis of an information. And an information comes from the prosecutor, and he or she will file an information. And after that is filed, there's a preliminary hearing, which is before a judge. These are the things that have to be determined. A crime was committed. B, it was committed within the jurisdiction, within the venue. And 3, is there reasonable grounds to believe that the accused committed the crime? Now, in the preliminary hearing, the accused knows he or she is accused. They get an opportunity to challenge the legal basis of their detention. So there's a lot more rights and protections with a preliminary hearing with the grand jury, but the grand jury is constitutionally guaranteed. There's the term information. Sometimes we have an issue of competency. Notice this is not insanity, but certainly from the time between the act and the trial, which could be a year or better in some cases, there may be a change in the defendant's mental status. If he or she is unable to contribute to their own defense, then they're not competent to stand trial. All right, we said after the indictment, after the accusation, would be arraignment. This is back in court. The defendant with his or her attorney will come to court. The judge will read the charges and ask the defendant to enter a plea. The most common pleas are guilty, not guilty, which would mean then it's going to go to trial, not guilty by reason of insanity, which means then there's going to be a mental health evaluation, guilty but mentally ill, or nolo contendere. Nolo contendere means no contest. It's essentially a plea of guilty in a criminal court, but in any subsequent civil suit, you still must prove all the facts. So if you plead guilty in court in a criminal case and you hurt somebody and they are going to sue you for damages, they can enter the criminal court's findings or your plea of guilty into the civil court, and then it's just a question of how much money it's worth. In nolo contendere, they have to prove the basis all from the groundwork up. But there are some limitations, so you can't use nolo contendere in every type of case. Okay, plea bargaining. All right, as we told you, there's a big backlog. It takes forever to get cases to trial. Plea bargaining is simply an agreement to plead guilty for some present or future consideration. Pleading guilty for some present or future consideration. Now, your book lists certain types of plea bargains. The number one form of plea bargaining is, this is what defendants want, they want to bargain for sentence. They want a guaranteed. If they're going to prison, they want to know how long. See, if it goes through the trial, the judge has that discretion. So, of course, they all want probation, but if you got 3 or 4 felonies priors, you're not going to get probation. And it depends somewhat on the facts of the case. But they would rather know they're getting 8 years. They want to know when they're going to get out. And they can know that from day one. Yeah. A second common one is bargain for charge. This is very common in first-degree murder cases because you can get the death penalty. So some will plead guilty to second-degree murder, or they'll get life in prison or life without parole. but they won't face the death penalty. There's also bargains for dropped charges. So let's say we arrest someone for burglary, and in the investigation we find evidence of 6 other burglaries in their barn or garage. Okay, they agree to plead guilty to the most recent, and all the others are dropped. Okay, or a lot of times, like in a bar fight, it's public intoxication, it's ag battery, it's 2 or 3 other disorderly conduct. So they'll drop all the other charges and prosecute on the most serious. And of course, the other one is a bargain for concurrent sentences. We make a distinction, and we'll talk about this later in, I think it's chapter 9, between concurrent and consecutive sentences. Concurrent means more than one sentence is running at the same time. So in those 7 burglaries, you may get 5 years for each burglary, but the sentences run concurrently. So the police solved 7 burglaries, the prosecutor got 7 convictions, and you went to prison for just 5 years. So consecutive means they run, inmates call it running wild, means one on top of the other. So I know someone who got a 20-year sentence for murder and 10 years for armed criminal action, and those were consecutive or running wild, so that means they're going to serve 30 years. Now, plea bargaining is so common. In fact, 90% of the felony cases in America do not go to trial. So we go on and on about our right to a trial by jury, but we waive it off most of the time. And these are the rules for the federal judges. They have to inform the defendant that of the rights that they're surrendering by pleading guilty, right to trial by jury, right against self-incrimination, everything else. They have to determine that the plea is voluntarily made. Any agreements between the prosecutor and defense. And there has to be a factual basis for the plea. Okay. So